Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday. It is May 18th, 2024. Want to welcome everybody to this Zoom meeting and those that are joining us on YouTube Live. If anybody was curious, the name of the song, Can't Help Falling in Love. This one was done by Haley Reinhardt. I know it's an Elvis Presley song, but I always like this edition of it. And hopefully you guys are not too young to know that song. In any event, I want to kick it off with a topic today dealing with artificial intelligence. I'm kind of an IT guy with the way I run my practice. So I came across, always was kind of very curious about artificial intelligence, and I always think of things that can help my practice. So I came up with a company that I have joined forces with, which the concept is that if you got a quick general question on landlord-tenant law, you have an easy way of getting it answered just by going to my website. So let's show you how this works, because I think you'll find it fascinating. So I'm going to go to my website right now, and let's do that. And now I am sharing that. So you should be able to see my website. My website is evict123.com. That's EVICT123.com. I think you can see it in the screen there. And if you go to this part here that I'm going to highlight, it's called Ask a Question. You're going to click on that. It's going to bring you to this screen here. This is our new chat feature. And if we click on it, it's going to ask you, and I made this a little larger so you guys can see it, what can I help you find or ask a question? So if you wanted to navigate something on my website and find out where it is, like free forms or a rental agreement, you would just on the bottom of this, fill this out on the bottom where it says message over there. And then it will actually respond to you, and it's really doing very well. The system is that I have been feeding it a lot of information dealing with landlord-tenant law, and I'm basically educating this artificial intelligence to know everything there is to know about landlord-tenant law. Now, these are general questions that you can ask of it, but Jesus, it's really been doing a very good job. And every day I've been feeding more information into it so that when you ask a question, you're probably going to get pretty close to a correct answer. And so you might want to play with that by going to my website. I do want to demonstrate something. So I have a question that I have put there. And that is, if I serve a 3-day notice, hopefully you can see that, everybody. If I serve a 3-day notice on May 16th, when does it expire? So if you hit the button over here, it's going to come up with an answer. And as you can see, it knew that you don't count weekends or judicial holidays, and therefore the notice is going to expire next week on May 22nd. So this is kind of wild technology. I'm going to, for the next week or so, keep adding in more information. And every time myself or any of my associates get a question that I think is pretty relevant, and the questions that we get asked all the time, I'm going to feed that into this machine here, and machine learning, that's what it is. And you guys can get a quick answer just by going to my website. Obviously, it's all free. And let's go back to me. So that's an exciting event that I think people will take advantage of. I do want to thank all the attendees who came out to the Pasadena Convention Center last week. It was really a well-versed amount of people that came there in attendance. I think I had only standing room only for my talk, but it was really a nice event, and I got to meet a lot of people who have said that they participated in this Zoom Landlord Talk Radio event that I hold every Saturday at 3 p.m. We're now going to open it up to questions. If you got a question, then I'm prepared to answer it to the best of my ability. Do not forget that this show and my responses are for informational purposes only. It's not a substitute for legal advice. But if you do have a question, happy to answer it. All you have to do is electronically raise your hand and I'll answer you. I'll ask of you and I'll unmute you at that time. So then at that point, you need to unmute yourself and you'll be able to ask your questions and I'll be able to respond to it. To electronically raise your hand, it's on the toolbar at the bottom of your Zoom screen if you're doing this on a Zoom. Otherwise, you'd be on YouTube Live, which is also available, but then again, you're not going to be able to participate in the show. Lastly, I wanted to tell you that if you have an existing case with my law firm, God bless you, and we're going to take care of you. But we do not talk about specific cases here in our Zoom meeting. You're going to need to call the office for that. This is open for general questions only. And with that, we're going to kick it off. The first person I'm going to ask is a person who I think I saw a lot of them this last week. Jim Polina, I'm going to ask you to unmute yourself, sir. And if you could unmute yourself, I'd appreciate it. Says you're open. Let's try it again for you, sir. Asking you. You should be there now. Maybe your mic is off. So, Jim, figure it out. I'm going to come back to you. Okay. Let's go to Sal. Sal, I'm going to ask you to unmute yourself.
Hello, Mr. Block. How you doing?
Good. You were getting me scared there with that pause. How can I help you, young sir?
Oh, so I was wondering, when would you recommend a motion for summary judgment on a contested case?
Well, it's not a matter of when, it's a matter of if. For the audience out there, what we're talking about is that you file an unlawful detainer and the tenant answers the unlawful detainer. And when a tenant answers the unlawful detainer, he has the right to have the matter heard in the format of a trial in front of a judge or in front of a jury. There are sometimes there's cases that are so one-sided in favor either of the plaintiff or the defendant, the landlord or the tenant, that you really don't need to go through a trial, that there's really what they call no triable issues of fact. And if there are no triable issues of fact, then quite frankly, you can file what they call a motion for summary judgment that would be heard by a judge. And if the judge, based on your declarations and the opposing declarations, determines that basically says, you know what, there's no issues here. We don't need a trial. I'm going to grant judgment in favor of either the defendant or the plaintiff, because either party can bring that. The problem with why it generally doesn't work in an unlawful detainer action in an eviction lawsuit is one of the things we have to prove is that the tenant got the initial notice. Let's pretend we're dealing with a notice to pay rent or quit. The tenant didn't pay rent. So of course we would serve a notice. We have a declaration by a process server. We even have a picture of the notice on the tenant's door. But if the tenant claims, for example, I never got the notice and that was all staged, well, as incredulous as that statement is, it still raises what they call a triable issue of fact. So on that basis, we could potentially lose that. In summary judgment motions, there's a certain amount of cost involved with that. The costs alone are about $600 that you have to pay to the court, and with filing fees and process serving fees. So we certainly have done summary judgment motions, and quite frankly, when we do them, we are successful, but it is a finite amount of times when we can do it based on usually unusual circumstances. Hopefully that answers your question, Sal. Any follow-up?
I'm just curious because you said finite circumstances. It seems like this question they could dispute, about the process service on any case.
They can, but sometimes in their answer, for example, they do not indicate that the they do not indicate that there was a problem with service. So based on that, they can't now, once they've already filed an answer to the case, raise that it is an issue. But again, it is in a finite amount of cases where we file summary judgment motions. And when we do file them, I can tell you we're probably successful, I would say, about 90% of the times. Anyway, thank you very much. I appreciate the question. And let's go see if we can go back to Jim. Jim, did you figure out your problem? I'm asking you to unmute. Well, I can tell you one thing, Jim. I think you need a new microphone because while you are unmuting yourself, we can't hear you. So let's move on to Sonia. Sonia, I'm going to ask you to unmute yourself.
Yeah, Dennis.
Hello, Sonia.
Hi. My question is like we have a lease that's going to be like in 2 months, 2.5 months, that's going to end, and we'd like to have the tenant remain. We just want to renew the lease so it continues, and we're okay with the lease amount. Now, do we have to sign the whole lease over again, or is there like a letter, an addendum that we could just sign that says it's just renewed for 1 year and that's it?
Okay. First of all, what city?
Pasadena.
Okay. Well, if you don't sign anything, the lease by operation of law, and certainly by the local ordinance in Pasadena, becomes a month-to-month tenancy. So you don't have to do anything. If you just wanted to stay there on a month-to-month tenancy, then you are fine with regard to doing absolutely nothing. If you want to commit the tenant to another year, and in the example that you're saying, his lease is going to be over, correct me if I'm wrong, on July 31st, correct?
You said August.
You said 2.5 months.
September.
Okay, so it's going to be over the end of August, right?
Yes.
Okay, so what you can do is sometime in August, present him with a new lease with the same terms. You might be able to raise the rent depending on the jurisdiction that you're in, Pasadena, whatever that rent increase is, unless we're talking about a single family home, then you could raise it to whatever you like. But basically use the same lease and hand it over to him in that month. And if in fact he wants to sign it, he can sign it. If he doesn't sign it, then you actually have the right to evict on the basis that he refused to sign a new lease for the same term. Now, the trick is if the lease ends in the end of September, I think that's what you said, then you do not want to take any rent for the month of October, because by taking rent, then you've created a month-to-month tenancy. So present him with that lease towards the end of September, see if he's willing to sign it. If your position is, I don't mind you staying, but I want you there only if you sign a new lease, then do not take rent in the quote 13th month, the month after that lease expires. Make a demand. If he doesn't, then you actually have the right to evict. But again, if you do nothing, no problem. He's there on a month-to-month tenancy.
Okay, thank you so much.
Very good question, Sonia. And we are going to move on to, let's move on to Jason. And by the way, we've got not so many callers who wants to talk to me today. So if you got a question, please move on. Actually, I said, Jason, I'm going to ask you, Jason, to unmute yourself.
Hello.
Hello, Jason.
Okay. Hi, Dennis. I have a question. I have a fourplex, and 3 of the units are under renovation. There's one tenant that's there that's paying below market rent. If that tenant wants to move into the newer remodeled unit, or if I was to offer that to the existing tenant, am I still obligated under rent control, or can I charge them market rate for the renovated unit?
Okay, first of all, what city?
Bakersfield.
Bakersfield. And did the other tenants just move, or you asked them to move because you were renovating the units?
All 3 of those tenants did move.
Okay.
I just kept that one because she was actually the only one that adhered to the rules.
Okay. Well, let me tell you, if she moves into another unit, you have the right to get market value for your unit, as long as she's out of that unit that she's currently in. If she stays in that unit, then this would be under statewide rent control, you're entitled to 5% plus the CPI for that area is a limitation on what you can ask for rent. But if you move this tenant into one of these other units, renovated or not, if she gets out of the unit that she's in and moves into any other unit, you have the right to charge market rent.
Okay, thank you so much, Dennis.
Good question. And let's move on to Austin. Kind of took you out of order there. Austin, are you there?
Yes. Hello, Dennis.
Hello, Austin.
Okay. Let's see. So, trying to house hack a fourplex in the city of Long Beach, and I found a unit that might work. It's a Section 8 unit that had a lease that was signed on April of 2019, a fixed term lease for a year, and is now, went month to month in April of 2020. So I believe SB 567 does not apply. So I don't need specific owner occupancy phraseology in the lease, nor do I need the tenant to sign an addendum to allow for that. But my question is specifically, I've never dealt with Section 8 tenants. Do they have eviction protections under the law for no fault just cause owner occupancy?
Under AB 1482, Section 8 is exempt for Section 8 tenancies. So that's number one. However, under Section 8 rules, you do have to have cause to evict. One cause is for economic reasons. Another one would be because you want to move into the unit yourself. So nothing prevents you from serving that tenant with a notice to vacate on the basis that you yourself want to move in. It is going to be a 90-day notice. You have to also send a copy of that notice to the Section 8, his Section 8 advisor. There's also special other documents that need to go with that notice under some federal law called the CARES Act. So generally in that type of a situation, you certainly have the right to do it. You should get use the services of a legal professional who knows what they're doing, so that the proper documentation is served on the tenant and also on the Section 8 as well.
Understood. Thank you very much.
Okay, you have a good day. Okay, let's move on. These are good questions today. Let's go to iPhone, it says. iPhone, I'm going to ask you to unmute yourself or there you go.
Hi, Dennis. How's it going?
It's good, thank you.
Question for you. So, is there a law that is in or it's coming in effect that if there's a tenant in a rent control, for example, paying $400 a month and they leave for whatever reason, is the replacement tenant supposed to be the same $400 or low rent?
The answer is right now we are protected on you're talking about vacancy decontrol, that once the tenant leaves, then it is decontrol, which means you can charge whatever you like coming in. Right now, under the current law, which was initiated back in 1995 under the law called Costa-Hawkins, we have the right, once there's a vacancy, to raise the rent to market level. Now, that being said, there's an initiative on the ballot called Justice for Tenants. That was sponsored by a guy by the name of Mitch Weinstein, who's head of the AIDS Foundation. He's had this initiative twice before, which lost, thank God, and now it's up again. And this is the so-called Justice for Tenants. It should be called another nail in the coffin for income property owners. This is really one of the worst pieces of legislation that we would hope that would never pass. So we want to make sure that we vote against, quote, justice for tenants. This will allow us, as you just stated, that if tenants move out, a local municipality could state, well, you're only entitled to a 10% rent increase. So this property that you were dying over for the last 15 years, where the tenant was only paying $100, presumably you would only be able to get 10%, and now you're up to a whopping $550. This is insanity. Costa-Hawkins also protect homeowners of houses, single-family homes, townhouses, and condominiums. Under that law, a landlord was always able to charge for market value anytime, anywhere, in the state of California, regardless of when those items were built, regardless of what city or local jurisdiction of rent control. If you've got a single family home, a townhouse, or a condo, you can raise the rent to market value anytime you like. There's no restrictions. If this law passes, ladies and gentlemen, you can see the floodgates will open, that all these municipalities that have instituted rent control will start on those first. And I'm telling you, the list of municipalities that have instituted rent control just goes on and on and on. We have it from, as I look up my list here, we have it from Culver City, Inglewood, Santa Monica, unincorporated areas of LA County, Cudahy. Cudahy has rent control. Ladies and gentlemen, Cudahy has 2 square blocks. What the hell do they need rent control for? Bell Gardens, Montebello, Pasadena, Santa Monica, West Hollywood, and I'm going to end it up with Pomona. That's just for the Southern California area, close to obviously LA County. But if this happens, then they're going to be able to, on single family homes, townhouses, condominiums, they're going to be able to institute rent control, and also, again, do away with vacancy decontrol. So this is really a scourge on us, and we really need to make sure that that we vote against that. So as I said at the lecture that I did at the Pasadena Convention Center, come November, make sure you go to the polls. Make sure that you take with you your family. Make sure you take with you your friends. If you've got a Great Dane, then I would like you to dress him up as a human and have him vote too, because we've got to defeat this. This will be terrible for this industry. Our industry is already in a tailspin. This will be the final nail in the coffin. Any other questions, Mr. iPhone?
And I don't know if you could answer this, but has this happened in other states or in California? And if it did it affect the real estate market or?
Well, it hasn't happened in the state of California because the Costa-Hawkins law that was instituted back in 1995 is still the law of the land unless this initiative passes, which is to do away with Costa-Hawkins. I'm not the only other place which would have crazy rent control laws, which I'm not aware of, is New York, specifically New York City. The landlords there are railing it. And I've heard stories that it takes 3 years to evict a tenant. I mean, I don't know how they expect the industry to survive, but I guess they just don't care, which is what this whole thing, ladies and gentlemen, the income property owners, landlords are the only industry in the United States that is singled out with rent control and the inability to exercise our legitimate contract rights. It's the only industry, from the car industry to farms, agriculture. We're the only ones that are regulated in terms of price controls, and they'll make the argument that, well, we need to have controls on residential properties because people need a place to live. Well, you want to know something? Babies need baby formula, and that's not regulated. Drugs aren't regulated. So we're the only industry. We're literally under attack by our politicians, and this is something that we have to really stand on our rights. And stand on our rights means that we have to for certain, we have to make sure that this law doesn't pass, and why I'm being an advocate with all the other apartment owners associations and realtor groups who know how impossible this will be if this passes. But also we need to make sure in terms of our own property, since in my shallow opinion, rent control is like a cancer. It is a cancer. It's against our free economy. And unfortunately, like cancer, it keeps growing. So if anybody's listening to me out there, my recommendation is any time you can get your rents up, even if it's the smallest percentage that the municipality would do, please do that. You have to try to get your property to market value. Once it's at market value, then you're somewhat protected. But if it's way below market and you're just feeling sorry for the tenants, then quite frankly, you're really not a person who deserves to be in the business of leasing property and should immediately sell your units. Anyway, thank you very much, Mr. iPhone. Good question. We're going to move on now to Willa. Willa, say hello by unmuting yourself.
Hi, Dennis.
Hi.
Thank you so much. So I am trying to get a tenant out. I have posted a 3-day comply or quit, and they are contesting almost everything in the 3-day comply or quit. What do I need to do to prove that it's right? Do I even have to? Is it up to them to defend themselves?
Well, here we go. What city are we talking about?
Los Angeles.
Is this under rent stabilization ordinance?
Yep.
Do you have a rental agreement signed by the tenant?
Yep.
Tell me precisely what provisions of the rental agreement they are violating.
Well, it depends on what tenant you ask about the tenant that I'm trying to get out.
Not the answer. What provisions of the rental agreement are they violating? I don't need to talk to a tenant. You know, I need to see that.
Yeah, they're disturbing the peace.
Okay, well, disturbing the peace is not a ground for using a notice to perform or quit.
They're
Disturbing,
annoying. I want them out.
we understand that, and I love the fact that you're asking this question, because this is what I get in the office. When you say the word disturbing the peace, when you say the word annoying, when you say
How about stalking? Can I accuse them of stalking?
Okay, here's the deal. Number one, when you're talking about a notice to perform or quit, in almost all circumstances, you're talking about something that you can touch. So for example, the rental agreement says that 2 people can live there and they got 3. I could touch the other person. They got a dog, says no dogs. I could touch the dog. They've made alterations to the premises. In that situation, you could touch those alterations. That's generally what a notice to perform or quit is based on.
Okay.
What you have is potentially a nuisance. And that's where
Okay.
the tenant is creating an unreasonable interference with the comfort, safety, and enjoyment of other residents. That would be, assuming you had that would be a 3-day notice to quit. It's kind of like saying, well, you know, you took a gun out and you shot 2 people, you know, in the common areas. So you know what? I'm going to give you a 3-day notice to stop killing people. And after the 3rd day, you can't kill anybody more. Now, that makes no sense. So the same thing is true with nuisance behavior. You know, if he lit somebody on fire, you could, I'm going to serve you a 3-day notice. Don't light anybody on fire anymore. So I'm trying to demonstrate that this is a nuisance is a 3-day notice to quit. Now, depending on what the tenants are doing, you're going to need to have, and the problem with that is you're going to need to have other tenants come to court to say that my life is being made miserable. Now,
Okay.
I heard what you said about stalking. So if the person is somebody's walking around and the person's right up to their back and following them around, that would be intimidating. If both people
No.
happen to be in the common areas at the same time, then quite frankly, that's not stalking. So why
That's
don't you
what it is. Yeah.
they just happen to be in the area at the same time?
They're what I'm hearing is that they've had to set written, and the tenant that I'm trying to get rid of has had to set verbal and written boundaries with other tenants in this building, 4 out of 60.
I don't understand what you mean. He's telling other tenants what they can and can't do?
He's telling other tenants to leave him alone, and these other tenants are calling him the problem, and they're putting,
Okay, so he's got a mental problem where he thinks everybody's against him, and he's walking up to them and says, basically, stop doing that. You're intimidating me. I don't want you to follow me.
I wasn't there is the problem. I
Okay,
wasn't there.
well, well, that's a problem, because you can't bring a nuisance case unless you get the complete facts from all the other residents. You got to get their names. You got to get when it occurred and what happened. So I need names, dates, and what they did. If I walk up to you every day and I say, "Have a good day, ma'am," that's nothing. Okay. If I walk
Mhm.
up to you and I say, I know you stole from me, something to that effect, then that might be something, but it has to be more than just one-time incidents. For example,
So if
how many units in the property?
60,
60. Of the other 59 units, how many are complaining?
2.
Okay, so you got 2 people complaining. So in order to see whether you have a good case or not, you've got to have a little interview with them, just like I'm doing to you now, and say, what is he doing? How often does he do it? What are the dates that he did it, or at least close? And precisely, what are the facts? And other than that, you've got 0.
So if I bring these other tenants to court, what are the chances that the tenant I'm trying to get out can defend themselves? Let's say I get the whole building to come.
Well,
Let's just
look,
say.
if you can get 3 or 4 tenants to come to say this guy's making my life miserable, you've got a 99% chance of winning, because I've got other tenants there. A lot of tenants are intimidated to go, especially when you have threats of violence and stuff, and they don't want their cars keyed, and they don't want threats of violence against them. So it's difficult to get them to court. But again, Willa, I'm listening to you, and I really haven't heard much as to the bad things that he's done in the
Okay.
building. So
Okay.
without getting
All
into
right.
too much more detail, this is really simple. First of all, you only got two
Yeah.
out of the other 59. You need to find out exactly what their stories are. Look, if the guy took a rock and hit one of them with it, or if the guy walked up to him and said, I'm going to kill you, that's pretty good. That's a threat of violence, and they'll take that. I don't need much after that. But if the guy's basically, hey, you're getting too close to me, you know what? I'd really have to evaluate that. So get the stories from these tenants, what happened, when it happened, and also would they be willing to go to court? Because if they're not willing to go to court, then we've got nothing, which unfortunately, the way the system works in most rent controlled areas, and certainly in Los Angeles, you've got yourself a really bad tenant who's really threatening people, right? But nobody else wants to go to court. So, and what those people are going to do is, you know what they do? They leave the building, which means the good people leave and the bad person stays. And this is what our city has encouraged, for bad people to take over buildings, because if I don't have a witness, then I can't evict you. I had proposed to the city council many years ago saying, look, on a rent controlled unit where he just moved in, I'm charging maximum rent. There's no economic incentive for me to kick him out. You should be allowed to get that person out within the first year, okay, without cause, because within the first year, the person's going to show their true colors. After that, okay, then I want to bring a bunch of witnesses. But you see, the problem now is these people are there, they're making havoc in the building, and you can't get anybody to go. I mean, we have subpoenaed people to come to court, and we've had some success on that. But again, it has to really rise to a level. The last thing I want to tell you is, and why we reject so many damn cases when on the phone, including today when I was taking a call from a woman from Glendale who was insisting that I take this case, and I was insisting I wasn't. One thing you have to realize, if you hire the good-looking, great attorney, Dennis Block, and we go to court and we lose, your life's going to be living hell with that bad tenant, because then they're empowered at that point. So for us, we take in literally hundreds of cases. I don't need an additional case. When we take in a case in our office, and this is true, ladies and gentlemen, from the beginning, things can happen, but from the beginning, I want a case that I know I'm going to have a client happy at the end. Because quite frankly, if I take in 600 cases or I take in 575 cases, it doesn't make much of a difference to me. We want to win the damn case.
This is excellent. Thank you, Dennis.
All right. Nice talking with you. Good question. We are moving on to CW. How are you? I think I saw you this week at the Pasadena Convention Center. Correct me if I'm wrong.
It's the previous convention, but yeah, we've talked face to face, and I appreciate your feedback. The last call, I don't know, gave me a lot of input. We have two tenants in an 8-unit building who are they're just incapable of taking care of the unit. Unfortunately, they were kind of handshaked in by my father-in-law many years ago, and we've taken over the responsibility since he passed away. we've got them to sign house rules, but not like official like rental agreements. I wouldn't call it a lease, but we did get them to sign house rules because, like I said, he sort of handshake these folks in, but we're trying to document every time we go in to fix something, that they're just incapable of, doing the basic maintenance that they need to do. There's water damage. They leave food out that attracts insects. And so I think these are things we can touch. I'm just like, how much of a case do I have to have against these folks before I would bring it to you?
Good question. First, what city?
Los Angeles, Mar Vista.
And it's under LA rent control, correct?
Yes, sir.
Okay, and what you're telling me is that your father-in-law, may he rest in peace, never had him sign a rental agreement.
Correct.
I have to take a look at the house rules, but I think we can make them abide by the house rules. And I'm sure somewhere in those house rules, it says that you have to keep the premises in a neat and sanitary condition or something to that effect, correct?
Yes.
Okay, so you have 2 tenants in this situation?
Yes.
Okay, so the first thing we would do would be to tell you, I don't want both cases. I want to do one at a time. Let's
Okay.
get rid of the first one. We'll pick the one which is the worst, because otherwise we get a concerted effort.
Right.
The 2 of them go to the same attorney and it becomes more of a horse and pony show. So what I would recommend is that let's pick the worst one. I want to take a look at the house rules to see if it's something that I can declare constitutes a contract. And based on that, we might be able to proceed forward with an eviction. Now, what we'd be serving them obviously is a 3-day notice to perform or quit. You're right, you can touch the garbage, and giving them 3 days to clean up the premises. And if they don't, then we have the right to bring forth an eviction. But again, I want to pick on the worst one first, because we have the best chance of getting that person out. Then once we're successful, then we take the other one in tow.
Okay, so quick follow-up on that. The folks that are the worst, they're also a nuisance, and we have the people that live under them. We gave them, we're trying to support them in this. They actually complained to us, so we wrote up a little form saying incident, description, time and date, signature, and with a bunch of lines on it. And we asked them, hey, every time they wake you up at 3 a.m, every time you hear yelling and screaming, write it down. If they fill out like this log and sign it, would that hold up in court, or would we still need to get them in to testify?
That would be considered hearsay. You have to have the person in court to testify. So the fact that you have a log means nothing. Under the law, you might have heard the expression that you have the right to confront your accusers.
Right.
And in that situation, that means that you can't use an out-of-court statement to prove the truth of the matter. So I would need them to come to court. But the reason why I'm glad you did that is because we have a way when we have reluctant witnesses. If I have a reluctant witness, what we would do in that situation is subpoena them to the court. Now, in most situations, they could get on the stand and say, I don't know, it doesn't bother me. They could change their story. But since you already have their log, presumably in their own handwriting, I could put that log in front of them and say, is this a log that you created? Yes. Well, let's go over here. I see a statement regarding an issue that occurred on March 25th. Can you read me what you wrote? And they're kind of stuck in cement to tell the story. So I like people, I'll tell people, don't worry, just sign a petition that you hate this guy and don't worry about it. And then when push comes to shove, and by the way, in most situations, I don't need any witnesses because it usually doesn't get to a trial. We settle with them or the tenant doesn't contest the proceedings. But there is a percentage of cases where I will need to have the witness come to court. Well, in that situation, if I've got anything, they signed a petition, they did this log, I can subpoena them if they won't come willingly, and then put them on the stand, and they're going to have to tell the truth. So, but you have to understand, you've got either or. Either we're going to go on the cleanliness issue, or we're going to go on the nuisance issue, because one is a 3-day notice to quit, the other is a 3-day notice to perform or quit. You can't do both at the same time. So also sometimes with regard to the cleanliness issue, we serve a 3-day notice. You have to be able to prove that the tenant did not clean up the premises after the 3rd day expired. Well, after the 3rd day expired, which means you're going to have to go in there. Well, what if the tenant doesn't let you in? Then what? So it becomes a more difficult case. And it's one thing if you're going to say extra person, you can see the people going out. If you knock on the door, you're going to hear the dog bark. If they're parking in the wrong spot, you can take a picture of that. But with regard to cleanliness, sometimes it's going to be more difficult to get in. So if you've got a real good witness who's going to come to court, the husband and wife downstairs who's saying what they're doing. Now, in multi-user family units, you're going to have noise, okay? So the issue is it abnormal? Is it something that, hey, you're right. At 3 o'clock in the morning, I get up and I walk around the property. I use the bathroom, maybe I take a shower, and I'm allowed to do that. And you know something? They are allowed to do that, okay? But if they're pounding and screaming and they have the TV to excessive levels, then that would be something that we could go after. Anyway, that's my discussion on nuisance versus notice to perform or quit. And I'm going to say goodbye to you, CW. And we are moving on. Well, let's try one
Okay,
more
thank
time.
you.
Okay. Thank you. Let's move on. Jim, I'm going to give you one last chance because you still got your hand raised. And
Here we go.
finally, what was going on, Jim? I gave you 3 chances.
Oh, I had a mic problem like you mentioned, but I fixed it. I figured it out.
Very good. I've seen a lot of you in the last couple of days.
Well, Dennis, I have to say something here. I've been a landlord for over 30 years, and I'm just shocked at how much I don't know. And I'm learning by attending your seminars and the Saturday Zoom meetings. It's well worth my time. Yeah. Well, you talked about something earlier, and I think I missed it. My daughter is a student at Sac State, Sacramento, and she lives in an apartment house off campus. She signed a 12-month lease, and and the lease states at the end, it rolls into a 12-month, or I'm sorry, it rolls into a month-to-month. We don't want to sign another 12-month lease. And they're pushing. They say, that's all they offer. I go, well, we don't want to sign. And I think you mentioned that if they present a lease to her, or I'm the guarantor, or to me, and we don't sign it, they have a right to give us a notice to vacate.
Okay, so let's clarify this. I believe, and I don't know because I don't handle that area, that Sacramento doesn't have local rent control. So if they don't have local rent control, then you're under statewide rent control. And there is a provision for asking a tenant to move for cause when the lease expires and the tenant is presented a new lease and the tenant refuses. However, they would have to, if this was a 12-month lease, they would have to present that lease sometime before the expiration of that lease and give them another opportunity to sign this new lease. But if they've accepted rent for the 13th month, they've created a month-to-month tenancy, whether they like it or not. And your daughter is now protected under statewide rent control, and there's no way that they can get rid of her.
Right, I understand that part. But if they do present a lease to us,
when?
Well, we have 45. It's a 60-day notice to present a vacating notice, and we're 10 days away from that 60-day period.
Okay, right now, she signed a 1-year lease. Are you still within the 1-year lease term?
Yeah. Terminates July 31.
Okay, so then you're dead. If they could definitely bring forth an eviction, as long as they don't accept rent for August, they could bring forth an eviction on the basis that you refuse to sign another 1-year lease.
Interesting. Okay, and they can do that like 1 day before July 31?
Yeah, as long as they don't accept rent for August, then, you guys can negotiate back and forth. But eventually, if you refuse to sign a similar lease, then they can ask you to move.
Thank you.
All right, take care. Okay, we are moving on to a regular by the name of Harold. Harold, I'm going to ask you to unmute yourself.
Dennis. Can you hear me?
Yes, sir.
All right, you can see me too. There I am. Man,
Ah,
this is like empowerment sessions, man. Your stuff that you have every week is just dynamite. I wanted to further the nuisance situation where you have. I'm in Just Cause, Woodland Hills, LA, single family, owner occupied. Now on the Just Cause, there's like only 4 reasons you can evict as far as Just Cause, I think.
no,
But
there's more. There's more.
Oh, okay, good. So in other words, there is judge's discretion. Like for instance, if the guy carries a gun and they didn't tell you in the beginning, is he allowed to?
If he's not violating any law by carrying a gun, then
Okay.
that's that. I mean, people are allowed to own, revolvers, and they keep them in their home. They don't carry them. But let's pretend the guy takes out the gun and starts pointing it at you. That would be an immediate case for a nuisance behavior, even though he has the right to own a gun and possess it.
Okay. What about if he signed the rules and he's like violating the rules? For instance, don't leave your clothes in the common area, and it's happened more than once. That's just for instance.
If that's specifically in the rules, and you serve that notice to perform or quit, and then you spot them again after the 3rd day, I think that's good. I mean, you both live there together, so you're allowed to have, rules regarding how you're going to have to live in your own house.
Right. What about, here's a couple other ones. If he's parading around in his underwear, or if in the morning is super loud at times, he's like hacking, you can hear it because he's so loud, or he sounds like he's gonna die, like he's coughing up stuff. He drinks a lot of times, and so all these things, I'm just collecting these possibilities. Like if I have to press the button.
I don't know about the coughing. I mean,
Okay. I mean, because if it's so loud, it wakes you up, or his
Right.
alarm can wake people up too.
Right. Well, then I think you need to tell him and do warning letters to him. If it continues and other people are complaining, then I think
Okay.
you have grounds. I mean, the fact that, I said, actually I don't, but I do get up at 3:30 and I could set my alarm and hey, that's when I have to get up. But
Yeah.
unfortunately, at my advanced age, that's when I get up. But I've actually done that my whole life. I've gotten up at 3:30. So, but lately I've been sleeping in a little bit longer, maybe 3:45. So I guess age is happening. But if he is creating a nuisance, but again, it has to be something substantial where it's happening all the time.
Well, like here's another one. Like he was like really loud last night, and then when I come home, I heard him loud, and then like 20 minutes later, he turned it down. But like if I said, hey, if I text him, hey, you're too loud, turn it down. But it's like a pattern. It's like it'll do it. He'll do it like in 3 or 4 weeks, and another time. But I'm saying if I have a pattern of text, like turn it down. At some point, can I say just not enough? I want you out.
Yeah, I think you're going to need to get with your warning letters. I think you need to say, look, this is happening far too often. If this continues to happen, then you're going to have to move because you're creating a nuisance.
Okay, good. So the good news about what you said is there's kind of like judge's discretion based on these other things that aren't necessarily the 4.
Well, I mean,
That's
it's always judges interpret the facts to the law. And, this is many years ago, commissioner I think it was in Van Nuys. In fact, I was socially friends with him and his last name was Block. No relation, I might add. And we had a case where a tenant punched the manager in the face on the property, unprovoked. We served a 3-day notice to quit based on nuisance, and Mitchell Block, commissioner at the time, hope he's still alive. He has retired since, said that wasn't a nuisance. It was a one-time thing. And I'm thinking to myself, well, sure, go take a gun out and shoot somebody. That's going to be a one-time thing too. So you're right. There is some judge's discretion on these. Anyway, thank you very much, Harold.
Yeah,
we're going to move on to James Rutowski. Say hello by unmuting yourself, sir.
Good afternoon, Mr. Block. I like your new pink color scheme. at the introduction of your presentation. I know you're a big proponent of rent increases. I'm wondering if you can qualify that a little bit, because I understand that there is some case law that suggests that if you raise it too high, then it becomes a constructive eviction. If the rent increase was meant to harass somebody or to drive them out summarily. So I'm wondering, is there any rule of thumb? Do you just
No.
raise it to market rent?
No, you can, I mean, obviously, if you're, let's pretend that you're in the city of Los Angeles, you need just cause to evict for a single family home, okay? And so you say, you know what, the house legitimately goes for $2,500 a month. So, you know what, I want you out. I don't really have, I want to sell the place, and I can't ask you to move because I want to sell the place. That's not considered just cause. So I'm going to raise your rent to $10,000. Now, in that situation, you're indirectly trying to evict them when you can't do it directly. So on that basis, that could be considered that you are trying to get around the law. Okay. By the way, I love the kids in the background. Okay. Anyway, hopefully that answers your question. I'm going to move on
Kids
to
are playing outside. Sorry.
quiet situation. I like that. But you know what? That's life, ladies and gentlemen. I have 3 kids too. And I just want you to know, if you think they're expensive now, oh my God. Right now, 2 of them are attorneys. The other one, they all work with me, and they're even more expensive now. So good luck, my friend. Let's move on to Kevin Davis. Kevin, I'm going to ask you to unmute yourself.
Hey, Dennis, calling about the balcony inspection thing, the new law. Nobody seems to know anything about this. I've talked to a lot of people in the business, and I don't know if I can have my general contractor do the inspection, if I need a specialist. What do you do with it? Is there paperwork I have to file?
Okay, first of all, you don't have to do this until January 1st of 2025. Technically, they're all supposed to be staircases, and balconies have to be inspected and certified by somebody who is licensed to do that. So it is a specific license. A lot of people are gaining their license credentials so that they will be able to perform this. I don't see many people doing it come January 1st, but I'll tell you when you're going to have to do it. Whenever you sell a building, you're going to need to have that certification. Otherwise, you're not going to be able to close escrow. I guess that they could come down hard on you if the balcony falls down and you never had it inspected. I had, and I'm so sorry that I lost this guy's card. He came up to me at the Pasadena Convention Center. I know his last name is Minas, M-I-N-A-S, and I forget.
I saw a guy in a booth at that show, the AOA show.
Yeah, in any event, he told me that the fees generally, which, I was thinking was going to be thousands. He said generally his fees were around $750. So not too bad. I'm wondering whether I have any balconies in any of my buildings. I think I do.
Yeah, I've got several. I just, and do you file paperwork somewhere? No one seems to know anything about this.
Well, you have to get it certified and just hang on to it. I don't think you have to send it in to anybody. But I'll tell you,
so there's nobody
once,
seems to know about this.
Yeah, it's once every 5 years. It's, if you just do a Google search, you'll find it. But a lot of people, hey, anybody want to get a great business? Get your certification.
Yeah, no kidding.
And go out there. It's just another money grab by officials who won't even use the inspection of balconies and staircases and making every income property owner do it. How about you guys inspect your own bridges, Mr. State of California? You're not doing that, but you're putting this on us. It's just another boondoggle to cost us more money.
Yeah. Okay. All right. Well, that kind of enlightens me on probably nothing's going to happen. So, okay, good.
Thank you very much, Kevin. And let's move on to Mike Laura. Mike Laura, I'm going to ask you to unmute yourself.
Hey, how you doing, Mr. Block?
I'm good, thanks.
Hey, thank you for the opportunity to ask you a few questions. So I bought this house in 2022 from my uncle, and they basically subdivided a portion of the house, and they have a family friend that rents that spot. That person stopped paying rent, uh, I think January this year, and I figured I could evict this person, but it turns out I can't even go through a traditional eviction process. I've been told that I have to, I guess, self-report to the city, and I'm not really sure how that would work or what all that entails.
Okay,
Or,
let's slow you down. Let me ask some questions, and I'll start with the one I always ask. What city is the property located in?
yeah, sorry, this is in East Los Angeles.
East Los Angeles. So you're on an unincorporated area of LA County, like your zip code is either 9002 or 22?
Yep, 22.
Perfect. Okay, and this is a single family home, at least that's the way it was constructed?
It is, yes, sir.
Okay, did you do the partition where you kind of made it into 2 units?
Well, there's a wall that was closed off. It used to be a door. And
Okay,
it was
but who
closed
did
off.
it? Your tenant or you?
No, that was done already. My uncle had that set up already when I bought the house. This is how I bought the house from my uncle.
Okay, so your uncle was trying to be an entrepreneur. He had a single family residence and a light bulb went off in his head saying, hey, you know what? If I seal off a wall, I can get 2 kitchens, 2 bathrooms, and I can make more money collectively by renting to 2 separate tenants. But unfortunately, if you do that, then neither tenant has the right has an obligation to pay rent. And you have to pay them thousands of dollars in relocation costs to get rid of them. For the city, for unincorporated of LA County, as I look up the chart here, let's see, LA County relo right there. It says here that each one has 1 bedroom, each side of the unit.
Yeah, the where I live, it's 2 in the front, and the back is just 1 bedroom.
Okay, so you're just renting out the back. You live there?
No, I own this house now, and I live in the front part, and the back part is the one that's rented, which is divided, and it's pretty much a 1 bedroom.
So there's 2 1 bedrooms back there.
Yeah, the back one is a 1 bedroom. The
Okay,
one
but
that's being
I don't understand. You said, okay, how many structures on the property?
It's just 1, but the house has a division now, and now the division in the back where they're living is a 1 bedroom pretty much.
Okay, that's fine, but you don't live in the front?
I do live in the front, and I live on the front part. Yeah.
Okay, so with regard to the 1 bedroom in the back, that tenant has no obligation to pay you rent. You have to get yourself turned in by calling the county building and safety or Los Angeles, get yourself in order to comply. Now, for a 1 bedroom apartment, you're going to have to pay this person. He doesn't have any children, does he?
Yeah, a 7-year-old.
Oh, perfect. Okay, so it's going to be $10,675 that you're going to need to pay him in relocation. You're also going to need to contract with a relocation specialist, so we have referrals for that, and that will help your tenant find another place. That those people charge on an hourly with a $2,500 to $3,000 retainer. So you're going to have to do that. An alternative would be to walk up to that guy and say, look, you know what? I need you out. I want the house all for myself. So here's $8,000. Would you want to move? You'll be ahead of the game. You won't have to hire an attorney if you can get him out on that basis. But otherwise, he has no obligation to pay rent. He has no obligation to move until you go through the procedures with the County of Los Angeles.
Okay. Okay.
All right. Thank you very much.
Thank you, Bob.
Okay, we're at 3:59. I got to go to a celebration today, but I see 2 iPhones. I'm not sure which one it is, but I'm going to unmute one. So, and somebody did it. Say hello.
Hello. Hi, Mr. Block. I had a question. So this is for the city of Los Angeles, and I have some tenants that owe me back rent from COVID days. And I've served them with a 3-day notice and have stopped accepting rent. I want to know if I did it the right way. Can I evict them this way, or is there a different process that I have to do?
lately, our position at the office is that we're not asking for rent that's for the city of Los Angeles that's older than 1 year. So right now we're in the month of May of 2024. So we would only go back to June of 2023 through May, only 1 year of 2024. If you're asking for rent older than that, we can still go forward with it, but it's been problematic because, and this is the upside down world that we live in. If the tenant admits that he didn't pay that previous rent because of COVID, or he told you that, then you're fine. But if the tenant walks in the court and says, 3 years ago, I withheld the rent, but it had nothing to do with COVID, then you lose the case. I know this sounds incredulous, but you lose the case because you're not allowed to ask for rent more than 1 year old unless the reason that they didn't pay the rent was COVID. Then the statute was told for that 1 year. But so we had a case where the tenant claimed, no, it had nothing to do with COVID. I'm just a bad guy and I don't feel like paying my rent. That guy got rewarded in that courtroom because they proved that we were asking for rent more than 1 year. So if you're sure that the reason they didn't pay the rent was because of COVID, then we have the right to proceed forward with that notice that you served.
And how can I prove that, for instance?
Well, you can prove that by saying, hey, I kept asking you for the rent. And you kept telling me it was COVID.
And if
Okay.
the tenant comes back saying it wasn't, or I didn't
Yeah,
say
it
that to you?
wasn't. I'm just a bad guy and I don't pay my debts. I had plenty of money to pay you. I just didn't want to. I was taking advantage of those stupid laws. Then you could lose that case. So that might be something that you want to talk to me about. Ladies and gentlemen, it is 4:02. Sorry that I didn't get to everybody, but I do want to wish everybody a great weekend. Remember that if you want to check out that new artificial intelligence to answer any of your questions, it will get better. I'm going to be working on it this weekend to get even better information into that machine learning process, but it is going to be fun to do. And everybody, great weekend, and thank you very much for coming. Guess what? Next Saturday, 3 p.m., I'm going to be here again. You take care, everybody.